You referred to an agreement of services with litigation cases. Do you actually require that or instigate that when it comes to that? Because I actually never know a litigation case where you had a service agreement.
I know, and it absolutely gobsmacks me that you don't insist that we sign one with you. Because by and large, an agreement for professional services is in actual fact drafted and exists primarily to protect the person who is engaged in giving the advice. So I'm very surprised that we don't get them pushed our way with back from you guys when we employ you to provide particular advice. I think that there are risks for professionals in acting as experts, and I would strongly recommend that next time we engage you to provide us with some advice, that you do insist that we sign a professional services agreement, or that the clients do, because primarily those terms of trade exist for your benefit.
Tim, you mentioned about limitation and limiting your exposure, I guess, through disclaimers and clauses and those sorts of things. Does that sort of restrict that limitation to being sued in contract or in tort? Where does it sit with regards to things like the Fair Trading Act?
Well, it's a difficult question. The Fair Trading Act you can't contract out of. So if you've got a disclaimer or a limitation in your terms of trade or your piece of advice attached to your advice, strictly speaking, the standard that you're measured against, certainly in a Fair Trading Act case, is whether there is you've been whether your conduct's been misleading and deceptive. So particularly whether your advice is misleading and deceptive. But those disclaimers remain relevant in making that assessment. So it will be less reasonable for somebody to have relied upon your advice thinking that you were, say, giving a concrete, this is what it's going to cost, if you put it clear in the piece of advice itself that that's not what you're doing. So they're still relevant, but strictly speaking, you can't contract out of your obligations under the FTA, nor can you contract out of your obligations under the Consumer Guarantees Act, which is an area which may be relevant, especially when you're dealing with domestic consumers, people in respect of their own private dwellings. Less of a problem in the commercial context because you can contract out in those circumstances. And I'd just be interested, how many people here would include in their terms of trade provisions that actually expressly contract out of the Consumer Guarantees Act if you can?
It's really commercial.
Yeah.
Business to business.
Business to business, you certainly can. And everyone should have appropriate terms of trade. You should have a solicitor check them and just make sure that you've done the most you can to make sure that you limit your exposure. Mostly your PI insurers will insist that you do that anyway, but that's something you should definitely look at. Especially, I know that there are a lot of one-person companies in this area, and there are some of those people here tonight. What you do is not without risk. You absolutely need to have appropriate PI cover, and you definitely should get some legal advice before you set forth to make sure your terms of trade are appropriate.
Are you just talking about a small contract agreement for any client, whatever it may be, like perhaps a house estimate or something like that? Talking about
I think
small contract.
I think even with a small contract, I would have standard terms of engagement. I mean, for my firm, we have standard terms of engagement which we apply in every case, no matter how big the instruction. And I think that's a practice that you all should adopt as well, for those that haven't already adopted it. It's not a question of size, because even a relatively small job, the biggest risk associated with anything is in this area is actually the risk that you will face a claim, because of the sorts of things that can do to your insurance premiums and just the hassle associated with it. I mean, if you can get in there with some terms of trade that make it clear what you're doing and what the limits on it are, that'll go a long way towards making sure the client's expectations of you are set at the right level, and that client is ultimately going to walk away satisfied with the work that they've done, because they've understood the basis upon which they've asked you to provide them with advice.
I was going to say, I mean, the advice we give on these insurance rebuild is not prescriptive. I mean, it's advice, it's an estimate, it's our opinion. How far out would we have to be for somebody to bother to come back and say, you've cost me enough?
Well, in my profession, we're currently plagued with a guy called Vince Seamer. Vince Seamer has a blog site called Kiwi Blog, which, if you're interested, you can have a look at. Now, essentially every lawyer that's ever acted for him, he's sued. For people like the Vince Seamers of this world, no matter how far out you are, if you're out, the Vince Seamers of this world are going to do something about it. That's a long way of saying really there isn't any safe margin for error. The question isn't not so much about how far out you were in terms of your advice versus the reality. It's a matter of how did you go about forming your advice? Did you use an appropriate methodology, an accepted methodology, and did you use proper skill and care based on the information you were given to form the opinion? So it's not a question simply about, well, was I within 10% or was I within 25%? It's a question of what was my method, and did I in fact do something that was appropriate to meet my professional obligations to that client. All right, well, that being a close to the questions, I'd like to thank you all very much. You've been a very patient and loving audience for me to speak to. And hopefully we can share a beer or two afterwards. Now that I've finished my talk, I'll avail myself of the opportunity to have another one. James.
Well, thank you, Tim, for coming along. There's some interesting things you brought up tonight, and food for thought for a lot of members, I think. On behalf of the Auckland Branch Board, it's a small token of appreciation.
News of my love of Pinot Noir has gotten out of the office. That's good.
Sorry, and also for those who haven't signed the register tonight, could you come and do it, or just about the front table here as well?
And could I have 50 smiling faces, please? For the e-bulletin?